in order to protect our country, a president can actually charge more tariffs than I was charging in the past period of a year under the various tariff authorities. So we can use other of the statutes, other of the tariff authorities, which have also been confirmed and are fully allowed. Therefore, effective immediately, all national security tariffs under Section 232 and existing Section 301 tariffs, they're existing, they're there, remain in place, fully in place, and in full force and effect. Today, I will sign an order to impose a 10% global tariff under Section 122 over and above our normal tariffs already being charged. And we're also initiating several Section 301 and other investigations to protect our country from unfair trading practices of other countries and companies.
All right, everyone, Adam is here. So what just happened, guys? Two things happened in the same week that legal scholars are calling the most dangerous combination any sitting president has faced in generations. The Supreme Court struck down his entire global tariff regime 6-3, with two of his own appointees in the majority, declaring his signature economic policy beyond his authority.
We begin with some news just in from the United States. The U.S. Supreme Court has struck down most of Donald Trump's tariffs on global trading partners. Justices ruled by 6 votes to 3 that Trump lacked the authority under an emergency powers law to impose the levies. This past year, Trump placed sweeping tariffs on dozens of nations that trade with the U.S. The president has called the case one of the most important in U.S. history, saying a ruling against him would be an economic body blow to the nation. Well, let's cross over to DW's Komodowski in Washington, D.C. Misha, tell us more about the Supreme Court ruling.
Well, Terry, the Supreme Court essentially says that President Trump went too far when he imposed sweeping tariffs under a law meant for national emergency.
At the exact same moment, nearly 100 lawmakers were quietly drafting impeachment articles and 25th Amendment measures targeting his unauthorized Iran campaign and pattern of emergency power abuses. Not fringe members, a coalition, a movement, the court dismantling his economic agenda, and Congress threatening his presidency, simultaneously feeding each other, with no off-ramp in sight.
Connecticut Congressman John Larson, who is up for re-election, has filed articles of impeachment against President Donald Trump. Larson says the move comes amid the unrest in the Middle East and the president's comments on social media recently this week.
Good morning, Bridget. Yeah, a lot of major updates over the course of the last 12 hours last night in Iran and at home with some of our local leaders. I'll start with John Larson. He filed articles of impeachment against the president, and he's also calling on the president's cabinet following this Iran war and some of the president's statements in recent times regarding Iran, some of the threats that he's made. He's calling to invoke the 25th Amendment. Now, what this would mean is that the vice president would basically take power, and this is typically used when the president dies or resigns or cannot discharge their duties. Now, Larson is calling for this because he says the president is putting our security at risk. Senator Chris Murphy joined in on these calls. Take a listen.
The president has promised to commit war crimes. He's promised to eradicate an entire civilization. We have never, ever seen that in the history of this country. That's why I and many other people have been talking for the last 24 hours about the 25th Amendment.
Now, take those two things separately. Each one is a major blow. A Supreme Court defeat on your signature economic policy. A growing impeachment coalition focused on your most controversial military action. Either one would be enough to dominate news cycles for weeks. Either one would be enough to send any normal president into crisis mode. But take them together. Take a Supreme Court that is systematically cutting back what Trump can do with the power of his presidency. And take a Congress that is systematically moving toward potentially cutting short the presidency itself. And you get something that legal analysts are struggling to describe because there is no modern precedent for it.
We start with the ongoing trade war and the latest US tariffs that have come into effect in recent hours. Right now, those duties stand at a 10% global levy, announced by President Trump after the Supreme Court struck down the complex array of unilateral tariffs imposed on imported goods into the US last year. A proposed higher 15% tariff announced on Saturday has not yet been formalized. Today's new rate, brought in under a different law to apply for about 150 days, or up to 150 days. And after that, Congress has to then authorize an extension. Now, on Monday, President Trump warned on Truth Social that any country that wants to play games with what he called the ridiculous Supreme Court decision will be met with a much higher tariff.
They are using a phrase that has never been applied to a sitting president in quite this way. His effective term is getting smaller, not his calendar term. The Constitution still gives him 4 years unless he is impeached and convicted or resigns. But the practical space within those 4 years where he can actually exercise the kind of executive power he came into office intending to exercise, that space is shrinking. Court ruling by court ruling, impeachment sponsor by impeachment sponsor, and the shrinking is accelerating. Let me explain the effective term concept, because this is the analytical key to understanding why this week matters more than any single court ruling or any single impeachment development could matter on its own. A president's constitutional term is fixed at 4 years by Article 2 of the Constitution. Nothing that happens in the courts or Congress changes that calendar unless it results in removal through the impeachment process. That is the calendar term. It is mechanical. It is automatic. It is the same for every president, regardless of how well or how poorly they govern. But there is another term that matters just as much, the effective term. The effective term is not about how long you are in office. It is about what you can actually accomplish with that time. It is about how much of your agenda remains executable. It is about how much political and legal authority you retain to govern as you intended to govern when you took the oath of office. Trump came into his second term with a specific theory of presidential power, broad emergency powers that could be invoked to reshape the economy through tariffs without going to Congress, executive authority that could be used aggressively to reshape immigration enforcement, federal agency behavior, and the administrative state, a theory of presidential immunity that would shield him from the most serious legal accountability, and a relationship with the Supreme Court justices he appointed that he expected would be broadly favorable to that theory of expanded executive power. Every piece of that framework has been eroding. The immunity theory has been narrowed by court rulings to exclude the unofficial private conduct where his most serious legal exposure lives. The emergency powers he used to impose sweeping tariffs have just been rejected by the Supreme Court as exceeding statutory authority. The lower courts have been systematically finding that his administration's actions in multiple domains exceeded constitutional or statutory limits. And the impeachment math, which started at a baseline of 140 members months ago, has been growing as each new constitutional violation adds to the documented case against him. The effective term is what remains after all of that erosion. It is the space where Trump can still act without immediate judicial reversal or congressional accountability. And this week's combination, the 6-3 tariff ruling plus nearly 100 lawmakers moving on impeachment and 25th Amendment measures, represents the most significant single-week reduction in that effective term since Trump took office for the second time. Let me walk you through exactly what the Supreme Court ruled on the tariffs and why 2 Trump appointees joining the majority makes this the most politically significant tariff decision since the post-World War II era. The legal question was straightforward. Did the International Emergency Economic Powers Act, the statute Trump invoked to impose his sweeping 10% blanket tariff on imports through executive action without specific congressional authorization, actually authorize the kind of broad global tariff scheme he put in place? The Supreme Court said no. 6-3. The court held that Trump's reading of the statute was too broad, that the emergency powers the statute provides do not extend to sweeping, comprehensive tariff regimes affecting essentially all imports from essentially all countries, and that imposing tariffs of that scope requires the kind of specific congressional authorization that emergency power statutes were never designed to provide as substitutes for. Now, why are the two Trump appointees joining the majority so significant? Because Trump spent enormous political capital on his Supreme Court appointments. He selected people he believed shared his constitutional philosophy and his understanding of executive authority. He expected loyalty. He expected favorable rulings. And two of those people looked at the tariff authority question and concluded that the Constitution and the statute simply did not support what Trump was claiming. They made a legal judgment based on the text of the law and the constitutional principles governing the separation of powers, not a political judgment about whether the tariffs were good policy, a legal judgment about whether the president had the authority to impose them the way he did, and they concluded he did not. That is judicial independence in the most direct and most consequential form. Judges appointed by a president ruling against that president because the law requires it. The result is a 6-3 majority striking down the central plank of the president's economic agenda. That is the most direct judicial reduction of presidential power through a Supreme Court ruling that has happened in this generation. But the downstream consequences extend well beyond the tariffs themselves. Because the ruling is not just saying Trump cannot impose these specific tariffs. It is establishing a principle about the limits of emergency powers authority that applies across every other domain where Trump has been or might want to invoke emergency powers. Every future emergency powers invocation is now evaluated against a Supreme Court precedent that says emergency powers statutes do not authorize broad transformative executive actions that lack specific statutory authorization. That is a constraint that applies to every future use of emergency authority. The tariff ruling cut Trump's effective term not just by eliminating the tariff policy, but by establishing the legal framework that makes it significantly harder to replace that policy with other expansive uses of emergency authority. Now let me talk about the Iran war powers situation, because this is where the impeachment case being developed by nearly 100 lawmakers is most legally grounded and most constitutionally significant. The war powers resolution requires the president to notify Congress within 48 hours of committing forces to hostilities and to seek authorization within 60 days. It is a federal statute. It creates specific legal obligations. And the documented record of Trump's conduct with respect to Iran military operations raises specific documented questions about whether those obligations were met. Military action was taken. The required notifications and the required authorizations are matters of documented public record, and the gap between what the war powers resolution requires and what the documentation shows happened is the legal core of the war powers impeachment charge being developed. The reason war powers is the textbook impeachment charge that makes the nearly 100 lawmakers effort more than political noise is precisely because it is grounded in a specific statutory and constitutional violation rather than a general accusation of bad behavior. When you impeach a president for lying in a private context or for conduct that is personal rather than official, the constitutional case is debatable. Legal scholars can argue about whether that rises to the level of high crimes and misdemeanors. But when you impeach a president for committing military forces without the statutory authorization that a specific federal law specifically requires, the constitutional case is grounded in the specific intersection of presidential war powers, the War Powers Resolution, and Congress's constitutional role in authorizing military action. That is a specific, documented, legally articulable constitutional violation, and that is why the lawmakers developing these articles are not dismissed by legal analysts as just doing political theater. They are doing constitutional work, and nearly 100 of them are doing it together. Let me also address the 25th Amendment measures being developed alongside the impeachment articles, because the simultaneous development of both tracks is significant. As we have covered in previous analyses, the 25th Amendment provides a mechanism for removal that does not require proof of specific crimes. It requires the vice president and a cabinet majority to declare the president unable to discharge his duties. The simultaneous development of 25th Amendment measures alongside impeachment articles by the same block of nearly 100 lawmakers signals something important about the strategic thinking behind this effort. The lawmakers developing these measures are not betting everything on one constitutional mechanism working. They are developing both mechanisms simultaneously, creating political and legal pressure on both tracks. The impeachment articles create pressure on the House to vote and on the Senate to convict. The 25th Amendment advocacy creates pressure on the cabinet to act. And the simultaneous pressure on both tracks is designed to maximize the probability that at least one of them eventually produces a formal accountability action. The nearly 100 number itself is significant context for what comes next. A baseline established through actual House floor votes previously showed 140 members supporting impeachment action. Nearly 100 members co-sponsoring or backing impeachment or 25th Amendment efforts specifically tied to the tariff ruling, the Iran war powers violations, and the pattern of emergency power abuses represents a developed and specific coalition that is larger and more specifically grounded than earlier impeachment efforts. And in an environment where the Supreme Court has just drawn hard judicial lines on emergency power authority through the tariff ruling, the congressional members developing impeachment articles have a new and powerful argument. The court has already found that Trump exceeded his constitutional authority in one major domain. The impeachment articles say Congress needs to formally respond to the pattern of exceeding constitutional authority before it happens in more domains with more serious consequences for national security and democratic governance. Here is the connection to the effective term concept that makes this week's combination so analytically significant. The tariff ruling reduces what Trump can do going forward with economic policy through executive authority. The war powers impeachment articles put him on notice that congressional accountability is coming for his Iran conduct. The nearly 100 lawmakers developing these measures establish a documented political record of what will be put to a full House vote if the political configuration changes in the upcoming midterms. All of that together means that the space within Trump's remaining time in office where he can take the kind of unilateral executive action he has been taking without triggering either judicial reversal or formal congressional accountability action is getting smaller. Not smaller in calendar terms, smaller in practical terms. Every emergency power used that gets struck down, every military action that gets documented as a war powers violation, every expansion of executive authority that gets labeled authoritarian or unconstitutional by a federal judge. Each of those events is a reduction in the effective term, and the reductions are accelerating. Let me give you 3 points that explain exactly why the combination of the tariff ruling and the growing impeachment coalition represents the most significant single-week reduction in Trump's effective presidential power of his second term. The 6-3 tariff ruling with 2 Trump appointees in the majority is the most direct judicial statement yet that the theory of expansive emergency presidential power that Trump's second-term governance was built on has been rejected by the court he built. The tariffs were not just a policy, they were a demonstration of presidential power, an exercise of executive authority through emergency power statutes that was designed to show what a president could do unilaterally without congressional authorization in the economic domain. The Supreme Court rejected that demonstration, said the authority claimed exceeded the authority available, and did it with a 6-3 majority that includes people Trump appointed. The message to the remaining years of the Trump presidency is specific and documented. Emergency power statutes do not substitute for congressional authorization in major policy domains. And that message coming from the court Trump built is a fundamental constraint on the theory of governance his second term was supposed to execute. The war powers impeachment charge being developed by nearly 100 lawmakers is the most constitutionally grounded impeachment charge that has been developed in Trump's entire legal and political saga, because it is based on a specific, documented violation of a specific federal statute that creates specific legal obligations. Every other category of impeachment charge that has been discussed across Trump's 2 terms has involved some level of factual and legal interpretation. But war powers is different. The war powers resolution is specific. Its notification and authorization requirements are specific. The documentation of whether those requirements were met in connection with Iran military operations is specific. And the gap between what the law requires and what the documentation shows is a specific, articulable, legally grounded basis for an impeachment charge that even skeptical members can evaluate against documented evidence rather than political judgment. That specificity is what makes the nearly 100 lawmakers developing these articles more than a protest movement. They are building a constitutional case. The combination of judicial power reduction through the tariff ruling and growing congressional accountability pressure through the impeachment coalition represents a compounding effect that is reducing Trump's effective presidential power faster than either track could reduce it alone. Because the judicial power reduction changes the political calculation for impeachment advocates. A Supreme Court that has already drawn hard lines on emergency power authority gives impeachment article drafters a clear constitutional framework to build their charges around, and the growing impeachment coalition changes the risk calculation for the executive branch as it considers future exercises of authority the court has not yet addressed. The judicial and congressional tracks are not just running in parallel. They are reinforcing each other. Each Supreme Court ruling that strikes down executive overreach makes the impeachment charge of systematic executive overreach more credible. Each impeachment article that is filed makes the executive branch calculate more carefully before the next overreach. The effective term is being compressed from both directions simultaneously. Now let me go deeper on what the effective term concept means practically for the rest of Trump's second term. Because the phrase is analytical, but the reality it describes is concrete. Let us think about what Trump came into his second term intending to accomplish, and how much of that agenda remains executable after the tariff ruling and the growing impeachment coalition. On the economic front, the tariff agenda was the flagship policy. It was the central promise of the economic nationalism brand. It was what Trump told his supporters would bring jobs back, reduce trade deficits, and demonstrate American economic strength. And the Supreme Court just struck down the central mechanism through which that agenda was being implemented. The blanket global tariffs are gone. The legal authority claim for them has been rejected. Replacement tariffs would face the same legal framework that the court just established. The economic nationalism flagship policy is judicially disabled. Whatever economic agenda the remaining term can execute has to be rebuilt around a different legal theory that is compatible with what the court just said emergency power statutes do and do not authorize. On the executive power front, the administration was building its second term around a theory of expansive presidential authority. The ability to fire independent officials and control the entire executive branch as a unitary instrument of presidential will. The ability to use emergency powers broadly to reshape policy without congressional authorization. The ability to direct federal law enforcement resources in ways that serve presidential interests. Court after court has been narrowing the space in which that theory operates. The immunity rulings have established that unofficial conduct is not protected. The tariff ruling has established that emergency powers do not authorize major policy transformations without specific statutory authorization. The lower court findings of executive overreach are establishing that the theory of unitary executive power has constitutional limits that courts will enforce. The executive power agenda is being eroded by judicial decisions that are establishing precedents for what the president cannot do, even if he is determined to do it. On the political front, the impeachment coalition growing toward 100 members who are specifically focused on war powers and emergency power abuses is establishing a documented record of congressional accountability demand that will shape how Trump's remaining time in office is politically evaluated. Every week that passes with nearly 100 lawmakers developing impeachment articles over his Iran conduct is a week that the political story of his presidency is about congressional accountability pressure rather than policy achievement. The political bandwidth that has to be devoted to responding to the growing impeachment coalition is bandwidth that is not available for advancing the remaining agenda. And the growing coalition has a specific mechanism to activate if the upcoming midterms produce a Democratic majority. The effective term is also shrinking in the sense that the political energy required to defend against accountability pressure is coming from the same finite reservoir as the political energy required to advance the remaining agenda, and the reservoir is not growing. Let me also address what the effective term framework means for the upcoming midterm elections specifically, because the midterms are the pivot point that could convert the current trajectory of effective term reduction into an actual calendar term reduction through impeachment. The tariff ruling gives Democratic candidates in competitive districts a clean economic accountability argument. Trump's tariffs cost you money and higher prices. They were struck down as illegal by the Supreme Court, including Trump's own appointees. Candidates can run on that story. The War Powers impeachment articles give progressive and safe-seat Democratic candidates a constitutional accountability argument that is grounded in documented evidence rather than political characterization. Trump launched military operations without the congressional authorization that federal law requires. Nearly 100 members of Congress have developed constitutional accountability measures in response. If you elect a Democratic majority, those accountability measures advance. That is a specific policy commitment on which candidates can run. The combination of economic accountability from the tariff failure and constitutional accountability from the war powers violations gives the Democratic coalition a multi-front argument for the midterms that is grounded in documented judicial and legislative record rather than political preference. Every ruling that reduces Trump's effective term also becomes a campaign argument. Every impeachment article development becomes a turnout motivator. The effective term reduction that is happening through judicial and congressional action is directly connected to the electoral calculus that will determine whether the calendar term gets cut short through impeachment. And Trump understands this connection, which is why his entire political operation for the remaining time in his second term is going to be built around preventing the midterm outcome that would activate the case that has been years in the making. The effective term is what is being fought over right now in courts and in Congress. The calendar term is what will be fought over in the midterm elections and potentially in an impeachment proceeding. And the two fights are connected in ways that make every court ruling and every impeachment-sponsored development not just a story about Trump's current presidency, but a story about whether his current presidency finishes on its own terms. Here is exactly where we stand. The Supreme Court ruled 6-3 to strike down Trump's sweeping global tariffs under the International Emergency Economic Powers Act, with 2 Trump appointees joining the majority. The ruling establishes a limiting principle on emergency powers authority that constrains future uses across multiple domains. Nearly 100 lawmakers are co-sponsoring or backing impeachment articles and 25th Amendment measures tied specifically to Trump's Iran war powers violations, emergency power abuses, and contempt for court-established limits. The tariff ruling has reduced what Trump can actually do with the remaining time in his term through executive authority. The growing impeachment coalition has put the constitutional accountability mechanism on an increasingly credible trajectory for activation if the political configuration changes. And the effective term, the practical space where Trump can exercise the kind of presidential power he came into office intending to exercise, is being compressed by both tracks simultaneously. The calendar term has not changed. The effective term is shrinking by the week. The phrase court ruling cuts term in the headline is precise in the analytical sense, even if it is imprecise in the literal sense. Courts cannot cut a president's calendar term. Only impeachment and conviction, death, or resignation can do that. But courts can cut a president's effective term by establishing that the theory of power on which the agenda was built is not constitutionally authorized. And that is what the 6-3 tariff ruling did. It cut the effective term of a presidency built on expansive emergency powers authority by establishing that those powers are not as expansive as the president claimed. Every future executive action taken under that legal theory is now evaluated against a Supreme Court precedent that limits it. The court did not remove Trump. It removed a significant portion of the power he was counting on to define his presidency. That is the cut. And nearly 100 lawmakers are working on the tools to cut further. The arc from the beginning of Trump's second term to where we are now is a consistent pattern of ambition meeting constitutional resistance. Broad emergency powers met the 6-3 tariff ruling. Permanent presidential immunity met the court rulings narrowing that protection. Unilateral military authority is meeting the war powers impeachment coalition. The effective term is the space that remains after the ambition meets the resistance. That space has been getting smaller with every ruling and every impeachment development. The court cut the term by cutting the power. The accountability movement is working on cutting the term by cutting the time. Together, they are writing the actual story of what this second term will be remembered for. Not the ambitions, not the promises, the resistance, the limits, the systematic judicial and congressional response to a presidency that tried to push beyond constitutional boundaries and found those boundaries holding firm.